Hi, welcome to Legal Considerations for Group Fitness Instructors. My name is Mark Nagel. I'm a professor in the Department of Sport and Entertainment Management at the University of South Carolina. I have a varied background in sport and entertainment management. I've actually worked in campus recreation for many years. I've also been a college basketball coach, and I've worked in a variety of other areas of this industry. I've been a professor since 1999, and I've worked quite a bit in the areas of facility management as well as legal and fitness management. So hopefully today we can talk a little bit about some legal considerations that will get you prepared to be a better professional within our field. The thing I always like to tell people first and foremost when talking about legal concepts is that ultimately when we're involved in the industry that we're in, everything you do needs to be explainable and defendable. So as you're going about your day-to-day jobs, as you're doing your things where you're training clients and so forth, you should always be asking yourself, could I explain what I'm doing to someone else? Could I defend what I'm doing to someone else? And it's important to think through that, not just could I explain this to another professional who has an advanced understanding of these concepts, but could I explain this to ultimately an attorney, a judge, or a jury if there was some sort of lawsuit that was to take place. Now, obviously, common sense in our society sometimes isn't common, but that's really what found in most lawsuits, and in many cases, just deal with the fact that someone didn't actually use common sense, and they did something that was outside the bounds of what their professional responsibilities are. So if it doesn't make sense for you to do something, it's probably a good idea not to do it. It's also important to remember that everything that you know about the law today can change. If we go back many, many years in the past, I always laugh when you talk to old school coaches, football coaches. It used to be acceptable to not have your athletes drink water on a summer day when you were practicing because you were going to get them tougher and you were going to get them stronger. Well, now the legal standards have clearly changed. If you're doing any type of activities, particularly those that are outside when the weather is very, very warm and humid, that obviously you need to have multiple water breaks. The same thing happens in our industry. Things change. What's acceptable or what was acceptable in 1985 may not be acceptable today. And what's acceptable today legally may not be acceptable in the near future. So it's important for you to go to conferences, interact with other professionals, talk to attorneys that work in the field, and make sure that you're reading and understanding how things are changing and how things are evolving under legal guidelines. And I always tell people that when I talk to them about go see an attorney early. And sometimes just one simple meeting with an attorney when you're getting ready to do your business and one simple meeting with an insurance agent when you're getting ready to do your business. Yes, some people you're going to have to pay a little bit of money for that, but it's always going to be easier to pay a little bit of money early with an attorney than to pay an attorney a lot of money later on. It's important to remember what your legal job is. We work in the fitness industry. We help people get stronger, to get faster, to get healthier. Okay? And what our job here today is not for you to become an attorney or even get on the roads of becoming an attorney. But your job today is to hopefully have a better understanding of the law so you can better able to converse with an attorney, so that you can actually make your activities legal, safe, and more effective. What you also have to remember is within that realm of what is your job, is you have to remember what are you and what are you not. We get people stronger. We get people healthier. We get people in better shape. Okay? We are not guidance counselors. We're not nutritionists. We're not doctors. We're not psychologists. And what you'll find in many cases if you spend some time studying our profession and studying where some of the biggest legal issues have occurred in our profession is they oftentimes have come because someone that's involved in making people stronger, faster, and healthier now has gone into areas where they're not an expertise, where they've actually gone out and prescribed medical advice, or they've gone out and given nutritional advice, or they've given comments to clients that go above and beyond their area of expertise. We always have to remember when dealing with clients is that we are there to train them. We are there to make them healthier. We're not there to be their psychologist. We're not there to be their guidance counselor, and we're certainly not there to be their medical doctor. It's very, very important that you understand what you are able to talk to clients about and what things you shouldn't talk to the clients about. Because in many cases, clients will listen very closely to what you say. And if you start saying you should do this and you should do that and you should eat this or you should do these types of things, clients in many cases will listen to what you say word for word. So be careful what you prescribe versus what you recommend versus what you advise. Because when we talk about prescription, that's usually what a doctor does. When we talk about advising, that's usually what we do in our field. So understand what your scope of practice is. One of the most important legal concepts that we all have to be aware of is the idea of negligence. Now, negligence is a civil wrong. We don't have time to go into the criminal justice system, but the criminal justice system, when we talk about criminal law, is when you're dealing with something where the state or the county or the federal government comes after you because you've done something that's criminally illegal. And that's usually where we deal with jail time and so forth. When we talk about civil law, we're talking about when one party does something to harm another party that's not going to be involving the federal, the state, or the local government. So when we talk about most aspects of our business, we're talking about negligence. Someone gets hurt because of something we did or something we didn't do. And they're going to now sue us in civil court. And that's important to remember, that negligence can be involving things that we actually did or things that we committed, or it could also be that we omitted or we failed to do something that we had a legal duty to provide. So we can't just say, well, I didn't do anything in this situation, so therefore I couldn't be negligent because I didn't do anything wrong. Because in fact, if I was supposed to do something and I failed to do that, I could be negligent. The elements of negligence are fairly simple: duty, breach, injury, and then damages. When we talk about duty as professionals, when we are training people, when we are helping people, we have a duty as a professional to people in our class or to people in our programs. Okay? And that's a different duty than we have if we're just walking down the street and someone gets hurt. We may have a moral duty in the real world if we're walking down the street and someone we don't know gets hurt to help them. But we don't necessarily have a legal duty. When we're training people, we actually have a legal duty in our classes and in our training sessions. So if we have a duty to do certain things and we do something wrong or we fail to do something that we're supposed to, that duty has now been breached. And if there's an injury that is caused as a direct result of that breach, then if there's any damages, and it's usually very easy for an attorney to find damages, someone got hurt, someone had problems, someone had something happen to them that they shouldn't have had happen, we now will have negligence. So we have to have all of these elements in our case to deal with negligence. And if those elements are there, we'll have a negligent situation. So when we talk about our industry, because negligence applies certainly to all professions, when we talk about our industry, there's a lot of things we need to think about. We need to think about, what was the instruction that we provided? Was it adequate? Did we have new people that have never done these types of exercise maneuvers? Did we have them do an advanced technique the 20 minutes after they started their protocols? Okay? Or did we provide them the proper instruction to get them from novice to expert? It's critical that we understand, what is the duty of care? What's the level of instruction we should have? And that level of instruction changes based upon potentially age, particularly for working with youth, experience level, and a variety of other things that can go into what type of instruction is adequate. We also have to look at supervision. Did we provide the adequate and appropriate level of supervision? If we're teaching a class and there's 95 people in the class, and someone gets hurt, and we're the only person in that class that's actually teaching and observing and trying to figure out what actually happened, the court system will oftentimes look at it and say, is it reasonable for one person to be able to supervise 95 people? So you have to look at, what are the industry standards for classes that I teach? What are the industry standards for group settings that I have? What are the industry standards for the different things that I'm trying to teach my clients? So we have to provide adequate and proper supervision. We also have to create an environment where the facilities are safe. And so this can involve any number of different things. It could involve, is the lighting properly set up? Is the floor safe and appropriate for use? Different types of floors are appropriate for different types of physical activity. You might need, in some cases, you might need a hardwood floor. In other cases, you might need something that's much softer if we were doing combatives. Something along the lines of, think about, is it appropriate, the facility that I have? We've also had many cases where air conditioning systems are not working, or heaters go on the fritz and won't turn off. Is my facility creating an environment that's safe and effective for me to undertake the activity that I'm doing that day? We also have to apply the same thing to equipment. Equipment that we use, whether it's devices that we have, whether it's weight training equipment, there's all sorts of different equipment that we utilize in our industry. Is that equipment safe? Is it appropriate? Is it recognized in our industry as being up to date? There's a lot of old equipment, some of you that have been in gyms that are 40, 50, 60 years old, and you see equipment that people utilized back 40, 50 years ago that may or may not have had safety catches on it, may or may not have had adequate padding. And particularly when we talk about equipment, in many cases, we have equipment that when we bought it is safe and effective. But if we don't have a good maintenance plan, that safe and effective equipment over many years and a lack of taking care of it and updating it and so forth, equipment that was once safe and effective can now be seen as unsafe and ineffective. The other thing we have to look at is transportation. And the thing I always tell people about transportation is we oftentimes fall into the trap. When we're usually teaching classes, it's not a big deal because transportation is not part of the activity the same way it might be if we were teaching a grade school class and we're now going to take kids on a field trip. That's a different type of transportation. What happens in our industry oftentimes is it's at the end of a class, you've had a great day, you've had a good session, everyone's had a good time, and one of your clients says, hey, can you give me a ride home? Now, when you give that client a ride home, you have now gone from teaching a class in a facility that would be appropriate. Now you've provided transportation to that client. And in many cases, if there's a car accident or there's something that happens in that car, you're now going to be seen as having that part of your job. And so you now have created a liability potentially by providing transportation when your job or the scope of your job does not entail that activity. When we talk about negligence defenses, and one of the unfortunate things about our society is people have a tendency to sue, and particularly for negligence, people have a tendency to sue for negligence quite often. Oh, I got hurt, or I don't feel something was appropriate, and so I'm just going to right away go to a lawsuit. And that's unfortunate. And the sad thing is, in most of our professional lives, if you spend 30, 40 years in this industry, chances are that either you or one of the employers that you work for, one of the gyms where you work, is probably going to be sued at some point. In many cases, these lawsuits are frivolous, or in many cases, these lawsuits are simply filed because they're trying to get a settlement. So one of the things that we want to think about is, particularly since negligence is such an important part of what we may be sued for, is can we defend against a negligence claim? Okay? Obviously, if any negligent element is missing, then there is no negligence. The other thing that we can use as a defense to a negligence lawsuit is there assumption of risk? And the idea of assumption of risk is we work in physical activity. Sports and exercise is by its very nature involves rigorous movement, jumping and throwing and movement and so forth, where there is some cases where you're going to get hurt. You hurt your knee, you hurt your ankle, you pull a muscle, and so forth. So one of the things we want to look at, just because someone gets hurt, and especially if they get hurt based upon something that was proper in regards to exercise, does that client actually have an assumption of risk? Now, one of the things that we have to make sure we do, we can't just say, oh, this person assumed the risk. Part of what we also want to do is, yes, they assumed that risk, but did they actually sign something that said that they had assumed that risk? Did they sign something, and there's another thing that oftentimes we'll see called informed consent. Did they have informed consent? Did they understand what they were getting into? Now, all of us that have been in the exercise industry understand that if you go for a bike ride, if you do jumping jacks, if you do weight training, if you run around a track, that there's a chance you could get hurt. But in many cases, we're dealing with clients that have no idea about the expectations of what an exercise class or what an exercise training session can do to them. So we want to make sure that they have assumed the risk of the exercise that they're going to do, that they have signed something that says they have been informed and they have given their consent. We also see in some cases documents called agreements to participate. And that basically is a document that has some of the same elements of assumption of risk and informed consent, but it basically says that client does in fact agree to participate in the activities that we are going to have. Now, there isn't enough time for us to go into all the legal minutia between the difference between assumption of risk, informed consent, and agreements to participate, but they're all very, very important documents, and the elements to them can help protect you, particularly if someone gets hurt, doing something that would be part of the normal course of an exercise activity. Now, the last legal document here, and the reason I've got it separated a little bit, is this idea of a waiver. Now, what a waiver does is it takes many of the elements of the previous documents I've discussed briefly here. But a waiver also includes an exculpatory clause, which says that you as the client are reading this and you fully understand what you're signing, and you also have agreed to waive your right to sue. And so that if something happens, that you are agreeing to waive your right to sue. And in many cases, a waiver is critical because someone may have a waiver that they sign and they later come back and try to sue you for negligence, and you can produce the waiver and say, no, this person agreed not to sue me. Now, it's very, very important with all of these documents that you seek an attorney, and not just any attorney, but an attorney who understands, number one, how the industry operates and what the accepted standards are within the industry, as well as what are the accepted standards within the state in which you work, as well as in some cases the city and or county in which you work. Every state has slightly different laws in regards to a variety of things, but certainly there's no exception within our exercise industry. California, Rhode Island, Minnesota, Florida may all have unique and different laws in regards to our industry. So you want to make sure that you don't just take a waiver that someone in the state of Washington wrote and was utilizing and now take it over to the state of Alabama and say, oh, well, this is the waiver that I have. There may be some things that are slightly different under Alabama law than there is under the state of Washington. So it's very, very important that you seek legal help, particularly when you're running classes and you're in charge of getting these waivers and these other documents signed by your clients. We always want to have clients sign these documents before the first day that they actually participate in some sort of exercise activity. There's been a lot of situations where people have said, oh, okay, well, you can sign that waiver, just sign it next time. You want to have them sign it before they engage in the exercise activity. One of the things that we also need to do, and this is an important part of being a professional in our field, is transfer potential liability. Okay? All of you should have professional liability insurance, something that covers you in the event that there is a problem on your job. Now, the nice thing about working with ACE is ACE has a wide variety of insurance products available, and given some of the expertise that they have and the relationships they have, in many cases they can guide you to appropriate people that can help you acquire liability insurance within your state or within your local area. So all of us should have professional liability insurance to cover us for situations that arise where we may be negligent, or in fact where we may not be negligent, but someone sues us. And unfortunately, the way the law works in many cases is it's easier for someone to set up a lawsuit against you than it is for you to get out of that lawsuit and to defend yourself. One of the things that we're also seeing more and more people advise, and I advise this tremendously for all clients, not just in whether it be in our industry or others, is to have an umbrella policy. What an umbrella policy does is it takes all of your other insurance that you have, whether it's your professional liability, your homeowners, your renter's insurance, your car insurance, and so forth, and it puts in place an umbrella that goes on top of all of those policies. And in many cases, those umbrella policies, you can get over $1 million in coverage for a very, very reasonable amount each year. And what the umbrella policy does is, if for some reason there's a successful lawsuit against you and your coverage only goes up to a certain amount with your professional liability or some other form of insurance, the umbrella policy then kicks in on top of that. Whenever you're dealing with insurance, it's critical to understand and know within your policy what is covered and what is not covered. That scenario I mentioned before about transportation and how easy it is for us as trainers or group fitness instructors to fall into the trap of giving a client a ride home after a workout. Well, that what ends up doing, if in that particular scenario, you may have auto insurance that covers you for having an accident. But the policy for that auto insurance may not actually allow you to be covered in the event of you driving someone in the scope of your employment or the scope of your profession. It may cover you for your family and your friends and just driving around recreationally, but now you've made that a work vehicle by taking a client along with you. So you have to know, what does my professional liability insurance cover? What does my umbrella policy cover? What does my auto insurance policy cover? Know exactly what's in all of that minutia so that you know, what am I covered for and what am I not covered for? And insurance companies in many cases year to year change policies. They may exclude, okay, now we're no longer going to permit this type of activity to be covered under your professional liability insurance. So you need to be aware of what's happening in your policies. You also need to be aware of, does your insurance policy provide money to help cover your legal costs? In many cases, the insurance provides money if you lose a lawsuit, but it doesn't necessarily help you to defend yourself against that lawsuit. And then the other thing that you have to look at too, in many cases, insurance companies look at the risk reward anytime a lawsuit is filed. So it may be a situation where someone files a lawsuit against you or against your place of employment, and you know you can win the case. But the insurance company may have the right under your policy to basically pay off or to settle that lawsuit, which makes it look like you actually did something wrong in a case where you didn't. So it's important to understand, what does your insurance policy cover? What does it do? What does it not do? One of the things that's critical for all of us in this industry is to understand, are we an employee or are we an independent contractor? And there's an important difference between the two. And what it really comes down to is control. Employees are under the control of the employer. Independent contractors are under the control of themselves. And the reason that this has become an important thing within our industry is gyms and other employers would like to classify everybody that works for them as independent contractors and not as employees, because employees have certain rights. Employees have rights to things like workman's comp and a number of other things that come with being an employee versus an independent contractor. And so in many cases, it becomes very much a gray area in our industry. Are you an employee or are you an independent contractor? And you, as the worker, would like to be classified as an employee. And as I mentioned before, the employer would like to have you classified as an independent contractor. So some things to understand that may come up if there is, in fact, a lawsuit or a dispute regarding the employment status of the employee or the independent contractor. The courts are going to look at things directly tied to who has control. Are you, as a group fitness instructor, keeping regular hours? So 4 days a week, 2 hours a day, you come and do work in this particular regular pattern. Okay? Or I come once a week, but the next week I come twice, and then the next week after that I come once again. It's more intermittent, and it's not a set schedule. Maybe part of the evaluation the courts utilize to determine if you're an employee or an independent contractor. And remember, just because the employer says that you're an independent contractor doesn't necessarily mean that's the official status. Are you paid by the job? Are you paid on a regular schedule? Were you trained when you were first hired, or did you come in with your expertise? There's a wide variety of other factors. Probably the best way to remember and think about independent contractor. A true independent contractor is someone like your plumber that comes to your house. You have a plumbing problem, you call the plumbing company, they send a plumber over, and he or she works to fix your sink or to fix your toilet or whatever else. They're working one time, they get paid by the job, you don't give them any tools, you don't really give them any instructions, they come and do the work, and when they're done, they're gone. That's the classic example of an independent contractor. Versus the employee, the classic example is someone that comes every day and works a regular schedule. In our industry, what happens, why there's a gray area, is because many of us don't work 40 hours a week for one particular place. We might work 20 here and 10 here and 5 here and so forth. In many cases, we may actually be seen as an employee, even if our employer doesn't want to classify us in that manner. And as I mentioned before, employees retain certain rights that independent contractors do not have. There's a number of things that go with that. As I mentioned, you may be eligible as an employee for workman's comp. You may be eligible for disability. If something were to happen, you would become disabled. If you're an employee, you have greater access to disability benefits than if you're an independent contractor. There may be some legal issues with leave of absences for a number of things, whether it be sickness or maternity or some of these other aspects of things under the law that you may have the right to have as an employee. What I always tell people is to remember, when in doubt, if you're the employer, when in doubt, assume that the people who work for you are going to be seen by the courts as employees and plan accordingly. And you, as an employee, unless it specifically says that you're an employee, assume that you're going to be an independent contractor. And there's one last thing that goes with this, and that's in regards to withholding of income taxes and so forth in regards to employment or independent contractor. Employers are required to treat their employees differently in how they compensate them and how much withholding they have. Independent contractors typically say the job is going to be $100 or the job is going to be $500. When they complete the job, they get paid, and the independent contractor is responsible for taking care of their own tax liability. So it's very, very important that you understand all the people who work with you or all the people who work for you, what is their classification as an employee or an independent contractor. One of the things we're seeing more and more in regards to legal issues in our profession is confidentiality. And that's really a part of our industry, is dealing and understanding with people losing weight, trying to get better health, trying to perform better with their exercise, and so forth. You as a teacher, you as an instructor, you as a trainer have a wide variety of information about people in your classes or in your training sessions. You know about successes and failures of people that you work with. It is critical that you keep confidential those personal attributes about people. And it's very, very easy, and it's very, very unfortunate that in many cases we start making offhanded comments about another client or someone else that we've been training, someone else that we've been an instructor for. And it's critical that you understand that much of that information about the performance that people have and the issues that people are struggling with, that is confidential. So it's critical that you maintain confidentiality of the clients that you work with. And that's also critical that you understand, particularly when you're an employer, when you have a variety of employees, that relationship, that job performance, and a number of other things that that employee does, that needs to remain confidential from the other employees. So confidentiality is a growing area of law across all spectrums of business, particularly in the information age. But it's really also become very, very important within our industry because of the things that we utilize and the things that we're exposed to, that in many cases is very sensitive personal information that should not be shared with others. What are some of the gray areas? And it's interesting, there's always questions that come up when I do talks like this, and one of the questions that always comes up is, can I work for multiple employers? Is that against the law? Do I have to have that in a contract? Do I have to sign an exclusive agreement? Can I push back on those things? And I think it's one of the things that's critical is to have good communication. I think it's always better to communicate and be professional on the front end than it is to try to figure out something on the back end. And so I think what's pretty standard in our industry is that it's expected, unless you're a full-time employee working 40 to 45 hours a week for one particular employer, it's expected that you may teach classes at this venue and you may teach classes at that venue. And you may do something over here and you may do something over there. And in most cases, employers or people that hire you as an independent contractor to teach classes or to do training sessions are not going to have a problem as long as everybody knows what's happening when the relationship starts. And ultimately, what an employer wants to know is, when you come to do your job at this particular gym, are you doing your job adequately for that employer? But I think it's critical, like anything else, understand that communication can head off a lot of potential legal issues. Now, there are some things that we need to be aware of, that there are, in fact, people that retaliate, restrict hours, or punish independent contractors who work at multiple places. That potentially can be against the law for them to do that. Now, it may be difficult to prove, but that is something you should think about. Employers cannot just retaliate because someone who has otherwise been doing a great job at this particular gym, they find out, oh, they're doing something in another gym. Unless there's some sort of legal requirement that says they can't do that, you can't just instantly retaliate against someone, right? There's an idea, we have here one of these bullet points that says restricted covenant or contract not to compete. This would actually be formal language that's written down and signed by both parties that would spell out exactly what each party can and can't do. Now, what we're seeing is more and more places that want to have more of an exclusive relationship with their best teachers, their best trainers, and so forth, are having them sign some sort of restricted covenant or covenant not to compete. And this is where it spells out specifically, you will work X number of hours and teach X number of classes for us, and we don't want you teaching any classes, or we want to limit the number of classes that you teach for other places. Now, what's critical about these is you have to be careful when you sign these. Make sure you understand what's the scope and what's the geography that you're eliminating yourself as an instructor. In many cases, it makes perfect sense. If you have a gym and then there's another gym that's less than a mile away, The first gym may want to hire you and may want to have you sign something that restricts your right to work for the gym that's a direct competitor less than a mile down the road. But that gym may be able to legally do that. It may be more difficult for them to get you to sign something that says you can't work for any other gym anywhere else in the entire metropolitan marketplace in which you work. So it's understanding what legally is allowed to be put into some of these things. In many cases, checking with an attorney can help save a lot of strife, both for the employer as well as the potential employee and or independent contractor. And again, communication, professionalism are critical. Ultimately, I hope that this seminar has helped you get at least introduced to some of the key legal concepts. Obviously, the law and how the law impacts our industry is something that we could spend hours and hours in class after class discussing. My hope is that this talk and some of the reading materials are going to help you better understand what you should do and what you shouldn't do. Thank you very much for your attention.